We have some expert opinions coming in as well. Ms. Abha Singh, a lawyer, joins us. Ms. Abha Singh, how do you respond to the judgment of the Supreme Court today, which has dismissed the petition filed on behalf of the mother, which had called for an abortion to her right to actually abort the child at 26 weeks of a pregnancy? That petition has now been refused by the court. Your response, ma'am?
I think the Supreme Court has rightly refused to give permission to abort a pregnancy as late as more than 26 weeks, because the court is there to uphold the law of the land as far as possible. And when the law is very clear in the termination of pregnancy that two registered medical practitioners would give up to 24 weeks opinion. And in this case, AIMS had clearly said that the fetus has a life and the heartbeat can be heard and the child may be born alive. So there are two factors on which a Supreme Court decides. One is the right to life, that about the fetus to be born, that if it has a heartbeat, and it can be born alive, so then you cannot abort it. And secondly, if it endangers the life of the mother. If you remember, as recently June 23, Bombay High Court, Aurangabad bench, it did not give permission to abort to a 15-year-old teenage girl who was a victim of a rape, and the pregnancy was an outcome of a rape because it was 28 weeks and the child would have been born alive. So in that case also, the 15-year-old girl had to go ahead with the full pregnancy. It was a 28-week pregnancy. So I think Supreme Court has gone by the law of the land, because it's very clear when the heartbeat is there, you cannot abort a right to life. And if you talk of bodily autonomy, I think till 24 weeks they should have exercised if they wanted to.
Absolutely. Thank you, Ms. Abha Singh, for your perspective on this. We also have Ms. Brinda Adige joining us from Bengaluru. Ms. Adige, how do you respond to what the Supreme Court has said today? Because repeatedly during the course of the hearings in this particular matter, the Supreme Court kept asking the mother in this case as to why she chose, as long as she did, to take this decision. If she had to really abort the child, she could have done it within the prescribed limit of 24 weeks.
That is a big question that a woman will be not able to answer immediately, because this particular woman is in that state of mind. The mental health of a person has to be considered when the Supreme Court is asking those questions. First and foremost, she already claims that she is suffering from various kinds of mental health issues. And she's also taking medication for it. So probably she was not able to make up her mind. She was not able to decide. Maybe going through a lot of other issues. We don't know. Every case is a special, different case, and the Supreme Court must look at it in that manner. And here saying that the bodily autonomy is not going to be given prominence, but the right of life should be, goes also to say that this woman is now going to live for the rest of her life, 40, 50 years, with a lot of other ailments, just because of a biological exercise. And then this biological exercise of delivering a child is not just delivering that child, it's also her entire heart, mind going into it. And that means she also will be living with the memories of all of this. So when the Supreme Court says, I gave you time, now you're coming to me and asking for this, and we don't want you to, we will not give that to you, is wrong, because that bodily autonomy also means the right and the choice of that person and her state of mind. That state of mind has not been upheld and respected by the Supreme Court. That is not acceptable.
Okay, Ms. Adige, that's a very interesting perspective, and it just goes to show how divided public opinion is over this particular issue. A heated debate on this particular matter, even in the Supreme Court. Harish, coming back to you, because Ms. Brinda Adige raised an important point. She says that the right to life of the child has been upheld in this particular case. There is also the question of bodily autonomy on the part of the mother, that she has a right to exercise her right in that regard as well. So let me therefore specifically ask you, what did the medical examinations actually say about whether or not there was actually any threat to the mother in the event that she decided to go ahead with the abortion? Was there any medical caveat that had been issued by those examining this mother in this case?
Yes, in fact, the bench led by Chief Justice Chandrachud very closely, in fact, not only once, twice this court sought a report from the AIMS board, and especially as, in fact, she was suffering from postpartum psycho.
Right, Harish, I'm so sorry, I need to interrupt you there, because we